So I want to first ask a rhetorical question, which is why are we here today on this bill? It's certainly not because Vermont has a violent crime or firearms crime problem. It's certainly not because there's a groundswell of support from Vermonters to demand action as now contained in S-141. The reason that we're here today is because Vermonters who care about our Second Amendment and Vermont Constitutional Article 16 rights have signed nearly 10,000 letters opposing new gun laws, and nearly 1,000 Vermonters attended the public hearing in February and called and emailed all of you folks. So in a sense, that's the people I represent, and as do my predecessors. The reason we're here looking deeply into this much more narrowly tailored bill is because of them and because of the all-important Heller versus D.C. and McDonald versus Chicago Supreme Court decisions. As a result of those decisions, state legislators and governors are taking longer, harder looks at their firearms laws, and in many cases overturning decades of unconstitutional statutes and regulations across the country. The nation, including states such as Illinois, are turning towards Vermont-style gun laws, which recognize an individual right to bear arms for the defense of themselves and the state, as does our Constitution here in Vermont. We oppose any and all arbitrary waiting periods following medical release for the purpose of seeking petition for release from the disability of this individual right. That, again, as Mr. Paquin and Mr. Bradley had stated earlier, it's about due process. It's about providing an adequate due process, and I think Senator Benning clearly stated that really at the heart of this is due process. And I would offer the definition as a non-attorney that due process is the thing that separates us in a constitutional republic from the rule of mob and makes it the rule of law.